along with his attorney of record, Ronald Wood. Sydney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections that are appropriate.
I did make them.
Okay.
So specifically, objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to...
Before we dive into this courtroom chaos, let me set the stage for you, because trust me, this one is a roller coaster of ego, legal confusion, and a judge who has absolutely zero patience left to give. Today we're entering the world of Antonio Perez Beal, a man who's decided he knows the law better than not only his own attorney, but also the judge, the world. The asterisk male Karen, also known as the Hihashira, who believes rules don't apply to him because he's pretty sure he read something online that says otherwise. And just wait until you hear the part where he threatens both attorneys' video. You're going to have opinions, big ones. So stay tuned, because things go downhill fast, and the judge, he's bringing the sledgehammer.
The court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could, and then once I did that, then I received wording from my client that he was did not approve of what I have objected to, and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd start sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections were.
Okay, pause for just a second, because this beginning tells you everything you need to know about where this hearing is headed. The judge is already trying to get a grip on the journal entry issues, which should be the easy part of a divorce case. But instead, he's opening with, where are we at? The courtroom equivalent of what fresh disaster am I stepping into today? Meanwhile, the wife's attorney comes in organized, prepared, documented, and calm, which is in hilarious contrast to how it's coming as set up is classic. One side has receipts neatly filed in alphabetical order, and the other side is approaching this like a group project they forgot about until 3 a.m. Keep watching. This tone is going to be...
It would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. The journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to a disciplinary administrator, that concerns me that I've got someone, watching over my shoulder. He doesn't trust my abilities to do the work that I'm doing, doesn't understand with 46 years of experience.
The moment where the curtain pulls back and we realize this hearing isn't just about a messy divorce. It's about an attorney desperately trying to exit stage left before his client drags him into an ethics complaint he didn't order, but somehow got delivered anyway. When an attorney says they want to withdraw, it's not because they're bored. It's because something has gone very, very wrong behind the scenes. The opposing attorney even says 80% of the objections aren't objections. They're basically, please undo everything the judge ruled because I disagree, which is like losing a game, then writing a letter requesting the referee change the score because you feel emotionally entitled to victory.
He continues to think that I'm not doing a job for him. Then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbiel says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right.
Imagine being a lawyer with 46 years of experience, 4 decades of courtroom battles, legal research, client management, and suddenly your biggest challenge isn't an aggressive opposing attorney or a complicated statute. No, It's your own client handing you 4 pages of internet-fueled legal corrections and demanding you submit them like they're gospel.mr. Wood is doing what every good attorney does: filter out the nonsense so the judge doesn't laugh him into another career field. But Antonio, he's not having it. He wants all his corrections included, whether they make legal sense or not. And when his attorney refuses, Antonio goes full tactical nuke by reporting him to the...
Right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, and I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor.
All right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then
Your
that's
Honor,
not objectionable. Okay,
may I make a statement?
Mr. Perez-Beal?
Yes, sir.
So-
That's me.
What's your statement?
My concern here is several things in the journal entry are not
This is the moment where the narrator absolutely nails it. The contrast between a seasoned attorney and a client armed with 46 minutes of Google research is peak courtroom comedy. And honestly, the saddest part is that this is exactly what judges deal with all the time. People underestimate just how complicated legal procedures are. They think if they read one article or watched one YouTube clip, they suddenly unlocked the legal equivalent of cheat codes. But instead of helping themselves, they end up derailing their own cases, alienating their lawyers, and, like here, threatening ethics complaints against people who are literally trying to help them. Antonio didn't just burn the bridge with his attorney. He lit on fire, danced on the ashes, and mailed smoke signals to the disciplinary committee.
written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administrator, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're
exchanges
getting
of
off the
court
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons.
time.
However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make, and the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there
Mr. Wood isn't trying to withdraw. He's begging for parole. This man is explaining, in the most diplomatic lawyer speak possible, that communication has broken down to the point where continuing representation is basically professional self-harm. When a client refuses to listen, refuses to trust you, refuses to accept legal reality, and reports you to the disciplinary board, there is no attorney alive who would stay on that case. You can hear the exhaustion in his voice. He's not even angry. He's defeated. Meanwhile, Antonio's choices are slowly painting him into a legal corner he won't escape easily. And the judge? He's well aware this is going downhill, but still trying to maintain order like a kindergarten teacher during a glitter spill.
Objection number 6, objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up the, Google it, USD 232 is DeSoto, Kansas, which is up towards Lenexa.
282.
All right, so number 13.
A lot of the
Schools,
objections,
why is that a problem?
a lot of the objections he made are not what I requested, and I'm getting ready to submit that,
All right.
what I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
Yes.
They
Yes,
do,
sir.
Your Honor.
Okay, so what's improper about 13? I
He
don't
has
see any
manipulated
problem
my
there.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk schools is specific enough. I'll overrule any objection to 13. Number 7 apparently has been corrected, Ms. Schooler, with the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yes.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in, I believe, June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Presbeel's income at $58,000. I think $230. I might be off on the last few dollars, but he was
58,320.
imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was imputed by you.
Email revelation is wild. Not only is Antonio sending disciplinary complaints about his own attorney, he's now CCing the opposing attorney too. Imagine being the other lawyer, simply doing your job, and suddenly you're dragged into someone else's meltdown because they don't like the ruling. This is the legal equivalent of hitty.